Hello, I'm Angela Princewell,
And I'm Shireen Abdi.
I'm Tavinda Barlas.
and we are back to talk about maximum parenting time. So we're just talking about a separate topic, and we were in a conversation, and we thought, you know what, we really need to put out this content very quickly, and we know that this is something that's weighing a lot on our clients' minds. So we want to be able to talk about how much parenting time you can get and what are the factors that a court or an arbitrator would be looking at, and most especially your settlement focused lawyers, what we will be looking at when we try to negotiate parenting time that's the maximum and in the best interest of the child. So I'm being very careful here because in the past we would throw out words like maximum contact principle. First off, this has been taken off of the Divorce Act of Canada, so it's no longer really a thing. But what we're talking about here, specifically in the Divorce Act, it says when allocating parenting time, the court will give effect to the principle that a child should have as much time with each spouse, parenting time with each spouse, as is consistent with the best interests of the child. So there's two parts to this. One, the child would have as much time with each parent, but it must be consistent with the best interests of the child. So I think this should be, do you think that do we even need to explain that sentence, or do you guys, what do you guys think? Is it self-explanatory? Because it sounds that
I
way
think
to
it
me.
will be self-explanatory if we talk about the best interest of the child, but I think the sentence is going to make as much sense as it's going to make right now.
Okay, that's I like that. So when a child is when a lot of times people come to us with this concept of 50-50. So Tabina, I know you do a lot of parenting matters, and as you can tell, there's nowhere in the act that anyone has a presumption of 50-50. So I would like you to just kind of weigh in on that based on your experience.
So basically, I mean, I've been on both sides of the table, Angela, I should say. I've been the lawyer where I'm requesting limited parenting time for my client. And on the other side, I've been a lawyer asking for the maximum contact. But I have to say that when you're asking for a limited contact with between the other party and your child, um, you have to take into consideration the risks of harm to the child, right? So unfortunately, there are clients that come in that are victims of domestic violence, and while that is considered, it's not one of the factors. Domestic violence on a spouse is different than the risk of harm to the child while the other parent is in a caregiving role. Totally different, right? I mean, yeah. So to begin, I'm just gonna say that I've been on both sides, and it's sometimes there are two sides of the argument.
Yeah, sure. Do you want to weigh in on sort of any background comments before we
Yeah,
jump
I
in?
mean, ideally, like the question is, I want to spend, you'll meet with someone who says, I want to spend as much time, or I want primary care and I want majority parenting time. And to be honest, the only test that you're required to meet is in what is the best interest of this child. So it's a non-exhaustive list. We'll go over essentially the different factors. I think that's very important. But there's going to be given considerations to multiple different things. It's not just one thing that you're going to look at. And I think that's the important consideration is people are like, well, how do I get parenting time? How do I get more time? How do I do this? What's in the child's best interest? That's the test that you have to meet. And then factoring in, obviously it's case specific depending on, the circumstances of each party, the living arrangements, the ability to be able to care for the child. So all of these things need to be taken into consideration.
Okay, so you're saying when your clients come to you and they say, I want 50-50, you're going to tell them, well, it depends on what's in the child's best interest. And that is essentially the correct answer, really, because the act kind of lists out what should be considered in the best interest of the child. And the very first thing is the physical, emotional, and psychological safety and well-being of the child. So I think again, that's one of those statements that goes without saying, right? Is how much time with you is good for their physical health. And I think that would tie into what Tamina was talking about, violence to the child, if that's something that existed. But the psychological one is, I think, something that the legal community, we struggle with a lot, right? And I know I've been on those discussions as well, where at one point I'm the person arguing that it's not good for the child to have this relationship, but more often than not, I'm arguing that it's essential to have that relationship, because not having a parent in a child's life, could would not be good for them psychologically in a lot of cases, right?
Yeah, of course. I think even recently you dealt with a case where it probably was a big psychological factor not to have parenting time with dad. The child was, identifying it in a different gender, and it became very problematic for father to accept that. So psychologically, the child did not feel comfortable having parenting time because father had not accepted the transition. And there's multiple, obviously different scenarios where this could play a factor, but there's always ways in which it psychologically, yes, it's great for the child to have contact with both parents, but then in situations like the one I just mentioned, it actually might do more harm than good.
Yeah, yeah, I did forget that case. That's a good point, because in that case we strongly believe that dad either needed to adjust his thinking, or parenting time needed to stop in that case. So another factor, so that's sort of the general thought behind it, right? So what's how keeping the child safe and secure, and making sure that their well-being is protected, is really at the core of it. So in determining that, the court would look at the child's needs, and I'm going to mention this, and we'll kind of talk about that. So the child's needs, give the child's age and stage of the development, and their need for stability. So when we had our conversation a few weeks back, and we're talking about parenting plan, I know this is something that we talked about, I mean, in terms of a child's age and how that could factor into sort of a parenting plan. And looks like this is a factor in determining the child's best interest. What do you think?
Absolutely. So, I mean, child's need and age, I think they go hand in hand. So, if you're talking about an infant child who's breastfeeding, that's different. And you may, as a parent, have limited contact at that stage of the child's life, versus if a child is 12 years of age, and they're a little bit more independent. That's when, and I'm kind of tying it to the other factor about their views and preferences, but really that's what we mean by the child's need. And stability is very important. So right now, I have a case where there's been a lot of instability in the children's life. They're 2 and 8 years old, and there's been a lot of moving around, right? So the courts do look at which parent can provide the most stable environment for their children.
Yep. Sharon, do you have anything you want to weigh in on that?
Yeah, no, I mean, just to maybe touch on Timinda's point, obviously, the best interest of an infant child is going to be different. While you might want equal amounts of parenting time, it just might not be feasible.
Yeah.
With an infant, the kind of details that you need, the logs, how often did they change, the diaper feedings, the consistent communication that's required. And the biggest consideration is, of course, if those parties do not get along, it's going to be quite, I mean, in my opinion, difficult to ascertain if the child's well-being and welfare is being looked after, especially if they're an infant child, that requires that consistent and very detail-oriented communication versus, a 10-year-old who can advocate, hey, I'm hungry, I have to do this. Like it's obviously quite easy in that sense. I mean, hopefully, but ideally, yeah, it's just getting a little more realistic in terms of where the child is at the current stage that you guys are coming to speak to the issue of parenting. If you're separating with an infant child, it might look a little different for the first couple of, months to years versus, a child that's, 2 or 3, and so just taking into consideration the age of the child, and it's an important factor.
Yeah, and the need for stability, right? That you guys had touched on earlier as well. I really like that one. It resonates with me a lot, because I have clients with older kids that maybe have children that are on the spectrum. So while you can have a child that's one child that's 10 years old and can run rogue and do whatever. For another child that's on the spectrum, you need to really manage that. Their bedtime routines mean so much more than for another child, or, a kind of the walk back from school for them is takes a higher level of importance in some cases than it will. So we need to look at sort of that stability and need. And we could go on and on about needs. I think I should move on, because so many examples just come to mind, children having allergies and things like that. So when you guys are speaking on the depth level of communication required, that's a factor. Now, I don't want to give, again, this impression that the fact that it's an infant means that 50-50 parenting, or if is not an option, or maybe if it's a case of a child breastfeeding, that dad cannot have more time. Again, we look at that child specific situation. If you guys are actually able to communicate in that level of detail, absolutely, why not? But I said I was gonna stop there, so I will. We'll talk about the next factor in considering a child's best interest is the nature and strength of the child's relationship with each spouse, maintenance of the child's relationship with the other spouse, and the persons that play an important role in the child's life. So the second factor sort of looks at all the relationships around the child, and I think this is pretty important stuff, right?
Oh, absolutely. For example, if there's an ability or inability for mom to be able to adequately facilitate time to dad, because I don't know, she hates him and doesn't want anything to do with him, and specifically interferes with his ability to parent this child, it's a factor. Because if mom can't make sure that dad has parenting time, maybe dad should be in the position of making decisions respecting that child, or have a majority of the parenting time if he's able to facilitate a more meaningful relationship. We understand that parties don't get along all the time, but you have to look at what's in the children's best interest, not your best interest. And while you might think that you might know the other party what's in the child's best interest, that's not the factor that the court determines. So the ability to make sure that you're able to maintain a relationship, or your child or children be able to maintain a relationship with the other party, is important, as well as its relationship to siblings. So for example, if you're not allowing parenting time to dad, and dad has two stepkids that grew up with the children, primarily they have a strong bond, and it's affecting their ability as well as the child's ability to maintain that connection, that's going to be a factor. So it's not all dealt with in a vacuum in terms of, this is what needs to be looked at, but these are real relationships. Another recent example is I had a grandparent that essentially was with this child for 12 years. So upon the separation, it was undoubtedly the child was actually 12. So for those 12-year period, this entire time, the grandparents were vital parts in the child's life. So it's important to make sure that maintaining those strengths and relationships between those children and obviously the grandparents is very important.
Yeah. Karina, anything?
Yeah, actually, I just want to on mentioning the grandparents. I just had an interesting court appearance the other day on a matter where both parties were working full time, and at the time that their youngest child was born, the grandparents moved in, with paternal grandparents moved in, and the judge really said, we want parents to be parents. Yes, it's important for the child to have a relationship with the grandparents. And when both parents were working, they may have looked after the kids, but now the circumstances are different. The parties have separated. Now the dad or the mom cannot rely on their parents to raise the child, right? Like if they're working, they got to think about other avenues such as daycare and stuff. So, I mean, it's interesting it's again, fact specific, but it's interesting when you go to court and you listen to the judge's point of view on different, judicial,
Yeah, no, that's definitely true. And I think that's why, again, alternative dispute resolution processes are probably ideal when dealing with parenting issues. But yeah, Shiri, you did on talking about that, you kind of touched on the third point, which is great. That's each spouse's willingness to support the development and maintenance of the child's relationship with the other spouse. And you talked about the siblings there. So there's a B and C kind of tied together, because yes, it's important to be able to facilitate this relationship. So when we're thinking, and again, remember the focus here is we're looking at what is the amount of time that this child should have with each parent. And I can't stress this enough. People come in with preconceived ideas. Most times people just say, yeah, so like you know how usually when people, divorce, he gets every other weekend and I get, like, there's no usual. There's really no usual. Even have clients tell me like, all my friends, yes, they just don't have parenting time. Like it doesn't work that way, right? So you don't know what factors existed in their case, or maybe they just had one parent that wasn't as particular as your ex, and really that person wants to have maximum time. So, if we're talking again, maximum time here, I always refer to 50-50 because I'm imagining where both parents are. We're not trying, there's nothing weighing in favor of one particular parent. So there's both equally capable parents. They both want equal amounts of time with the child. Well, is that really in the child's best interest, right? It might be maximum time for both parents, but is it best for them? So I'm going to jump to D, the history of care of the child. We spend so much time on this one, Tabina. I'm going to let you jump in on this because I think a lot of time is spent talking about the history of care of the child.
Exactly. So in a case where, and I'm going to use a mom and a dad, right? Where a dad is working full-time, mom with an agreement choose to remain home. If she is the parent that is dealing with the basic necessities of the kids, picking them up, dropping them off at daycare or school, you have to look at, I know for a lot of people, well, my partner wasn't present at the time of birth. That is something different. That's not really what the court look at, but yes, they do look at the fact that, okay, who has historically really taken care of the child, right? But they also take into consideration, okay, if one parent is staying behind taking care of the kid, well, the other party is really earning to put some food on the table. So there's some compromise. Yeah.
I think I've taken issue with that myself in the past where I'm like, well, the arrangements people make when they're together, the considerations are different. And hey, I make those arguments too. Dad took the kids to all the doctor's appointments and did all the dentist appointments and, did all the nighttime routines. And those are very important and special moments, but it might have been okay in the context of when you were together. And I know, Shireen, that's been your experience as well, where we've had clients where they would just they actually change their schedules. I have had clients that actually would take a pay cut to not have to travel as much because now they're separated and they want to be present. So holding sort of the history of the care of the child, while it's important, we need to remember that all of these things we're talking about are factors, and the court's going to be weighing all of these factors. And so the fact that you've done everything in the past may be relevant to you being, having more time and the other party having less time, but it doesn't necessarily have to play out that way, right?
Yeah, I'll say in a way that a judge put it to me, what you did while you guys were together and while everything, as he called it, hunky-dory, that's not what we're dealing with now. And a separation is a new leaf that must be addressed. And essentially what he's saying is whatever the status quo may have been, and it could be relevant to the circumstance of understanding what is in the best interest of the child, but it doesn't mean that, if historically dad has been watching the child, ongoing, that dad will continue to adjust. And like you said, families make decisions while they're together, factoring in the fact that they're still a nuclear unit. But upon separation, things change, and if they want more involvement, parenting time, there's more time to split usually upon that, right? So at the end of the day, like history and care, like I just urge people to think a little more realistically about the arrangements. Just because that's been the arrangement doesn't mean it will be the arrangement going forward. So just keep an open mind.
Yeah. Another big one is the child's views and preferences, and of course, giving due weight to age, maturity, where it can be ascertained. So I love when I can get a child's views and preferences. No, I don't always love it.
um Yeah, the views and preferences of a child are quite, in my opinion, depending on how old the child, are very important. So, the courts historically will look at a child usually of the age of 12 or more. I've had situations where if the child was mature enough and eloquent enough to voice their opinions, then even as young as 8 to 9, 10 years old can be ascertained, as long as the true views and preferences can be ascertained. And the court, because the children are not direct in terms of being able to participate in the court proceedings by being able to just testify about what they'd like, or have documentation about what they really want. You have to get third parties to get in there to kind of ascertain what are the true views and preferences of a child. Obviously, if a child is 15 years old and doesn't want to see mom and dad, it's going to be very difficult to throw a 15-year-old in the car and force them out the door. As if you are a parent, I'm sure you've even had difficulty doing that to a 7-year-old. So it's going to be a little unrealistic. I've had clients come in that their children are definitely 14, 15 years old, and they don't have a great relationship with the child, and expect that they're going to be the primary caregiver for this child who doesn't want to spend any time with them. And for me, I would probably look at more therapeutic interventions to repair the relationship before kind of seeking a parenting order. But the court is very reluctant to force a child of that age to go with mom or dad in that scenario. So they're quite important. They're not the only factor, but again, if they're old enough, it's an important factor.
Yeah. Davina?
No, I think Shreen covered
Sure.
it really well.
Okay, perfect. Yeah, the only thing I would add, honestly, yeah, and I think I take it from what you were saying, Shireen, is in terms of, you said the true views. And I like that you use that word, because that's always a source of conflict, right? We're never really sure when it's true views versus it being coached. So and there's ways around that. And then you said something else that I found interesting as well, which is the child, like kids not testifying in court. And I think for those that are uninitiated in the court processes, they think, well, yeah, my child is 12, they're going to come to court and they're going to say this and that and that. No, they're not. We're not going to let that happen. First and foremost, I don't think it's appropriate. And but of course you're the parent, so you might think so, and I defer to you, but the judge is not going to defer to you, because there's skills around interviewing a child, and lawyers, we don't have those skills. So there's people with more social work, mental health background that help us ascertain the views and preferences of a child. But if there's one argument that I've made one time too many, it's to remind parties at the courts that the views and preferences of a child is just one factor. I find that the older the child is, and I love the ages that Shireen was throwing out, because when they're older like that, well, 15, 16, honestly, I might start to throw in the towel a little bit. But when it's like 10, when the child's like 10
Yeah.
and 12, like, I know even if your views are clear and uncoached and is your opinion, respectfully, dear child, you may not know what's best for you. So if we're looking at what's in the best interest of the child, I appreciate the child's views, but it's only one factor. We still need to look at all the things we talked about: history of care, the child's needs, the interest, stability for the child, maintaining and fostering those relationships that are important in the child's life. Those are all factors that are just as important as the child's views and preferences.
Yeah, like, and I can spin it too in like a very simplistic way just to kind of illustrate like the age gap. So for example, if an 8 or 9 year old wants to voice his opinion respecting parenting and wants to live with mom because mom's the fun parent. Mom, they have a great time together. But dad has more stability. He could offer the child a stable schedule. Maybe he's not been attending school in mom's care. So there's so many different factors. So in that situation, even if they got the true views and preferences of the child, they're not meeting the other factors, at least on the eligibility requirements of, okay, what is maybe in this child's best interest is not to have fun parent, maybe to have fun parent, during the weekend, and maybe live primarily with dad, because he's able to offer the child, amongst the non-exhaustive list, a better stable environment that would, flourish his welfare and things like that. So I thought that maybe that might illustration might help, but I don't know if it helped or hurt, but I'm sorry if I did hurt it a little, but hopefully not.
But yeah, so let's talk about the next factor, which is the child's cultural, linguistic, religious, spiritual upbringing, the child's heritage, including indigenous heritage. I think this is an interesting one because I have had to actually believe this case in our firm went all the way to an appeal stage, and it involved a biracial couple, and a maximum parenting time in that case kind of drilled down to the importance of the child spending the same amount of time in both households. There's a lot of talk about race relations and things like that. It's important, for the child to be able to be exposed to both sides of their heritage. So that's I think is an important factor, and it's something that weighs in it's something that we would look at when looking at the best interest of the child. But it triggered a memory of a case that really, this became sort of the factor that was going to tip the scales one way or the other. And I, of course, thought it was very important for the child to have that exposure to both cultures, right? Any thoughts, memories on that?
No, I say this to say that, every household is different. If religion is a big part of this child's life throughout, the entire year, and then not just 1 year, sorry, throughout, let's call it 12
Mhm.
years, and maybe upon the separation, mom no longer, is religious, and dad wants to ensure that that religious views is continue, because that's historically what the child, until the child's able to identify what a religion is based on them, but they're still minors. These are still, decisions that need to be made, and they're important in terms of upbringing. And I think based on, the different races, as well as in your example, it's incredibly important, especially if you have different races, for both children, for both parties to raise a child that's adaptive to, their identity, both parents' identity, I should say, or
No,
identify.
I agree. Maximum principle in that context or maximum parenting time, I should say, in that context requires as much time again as is reasonably possible. In the particular case I was thinking about, for me, it looked like spending 50% of the time with each other. Actually, to be more specific, it was more a week about. So 1 week with one parent and the other week with the other parent. And in one parent's household, it involved, exposure to cousins and grandparents and a large extended family. The other home was a little bit more laid back and all of that. And I think the child could benefit from sort of having those relationships, right? Yeah. Oh,
Absolutely.
Absolutely. Absolutely. Yes.
okay. And well, part of looking at the best interest of the child is any plans for the care for the child's care. So if you want to know about plans for a child's care, I think we might have covered that in a previous topic. So that's something that would be considered. But when you start a court application, for example, you're required to kind of provide that information. But when we talk about, just very briefly, on the plans for a child's care, well, if you have so during the pandemic, a lot of people placed a lot of importance on this factor because some people were able to work from home, and those in the front lines almost appeared to be at a disadvantage because for nurses, doctors, and people like that, separating, it was almost like, well, he works outside the home and he, is exposed to COVID, and I'm the better parent to have this child. And so that was, again, that wasn't just fact specific, it was time specific. But fast forward, a few months now with all restrictions dropped, I still hear people saying things like, I work from home and I could take care of the child. And that might be fantastic. And it might save on daycare costs. But guess what? For some people, daycare might be appropriate so they can get that exposure. To me, I don't know if you have anything to weigh in on that subject.
I do actually, and circling back to the same file, the courts do acknowledge that just because, well, yes, circumstances have changed, dynamics of working from home, and working in the office, they have changed. But even when you're saying, oh, I'm working from home, I'm able to care for my child, the judge or the court in that instance said, realistically, if you're working 9 to 5 and if you're truly working, then how much time can you really truly put towards caring for the child, right? So you can't work a full 8 hour and expect that, oh, I'm also going to care full time. My child doesn't need to go to the daycare. That's not a good argument. Just because you're working from home and you want maximum time with your child, you can't say, oh, I'm working from home, I can care for my child. No, you actually need to work during those 8 hours.
I like that. I think you actually even touched on the next factor, which is the ability and willingness of each person to care for. Because you're right, like it's so easy to just say I work from home, but are you actually caring for the child? And so, we have to look beyond sort of the surface. So your plan must also make sense. So I'm going to jump to the other factor, which is any what sorry no this is still talks on the ability and willingness of each person with respect to which an order is made, um, to communicate and cooperate with the other parent on issues affecting the child. And I think it was Shireen that kind of touched on this very early on. And this is pretty important because if you're going to have equal amount of time, it requires a certain level of cooperation. Actually, I'm going to walk that back a little because it depends again on age, needs, and that's why these factors all kind of tie together. Because in my mind, I'm thinking, well, if we're talking about a child without special needs that's say 12 years old, they might having a 50-50 parenting schedule might work better because if you're doing say pick up at school on Fridays or something, then it reduces the parents kind of seeing each other. The child can maybe sometimes take their books back and forth. Like it might actually be helpful. But then when you're dealing with younger children, a week about is not necessarily encouraged. And then now you're dealing with just milestones and steps and details. So I don't know, cooperation takes a whole life of its own. Shireen, any thoughts?
No, I mean, I agree. Like, it doesn't get beyond that. At the end of the day, like, you guys do have to cooperate. And I mean, in terms of like sharing information that affects this child, like, report cards, it's say, there's issues with the school and there needs to be communication about, steps to address behavioral issues or, if there's medical concerns, the ability to be able to communicate in a way. And I'm not saying there's such a thing as perfect parenting. If so, I've never seen it. But in terms of just kind of being able to communicate the direct things that are affecting the child, obviously those things would look different on a child depending if they're infant or if they're older. It changes as things change, and again on a case by case basis.
Yeah. Sorry, Tabina, looked like you wanted to add something there.
Yeah, I just wanted to focus on the communication part. I think when you're looking to have maximum parenting time with your child, it's important that you are able to communicate with the other party. If you come and say, oh, our communication is not good, we can't talk, we're not respectful, well, then how are you even going to try to, decision making is a separate topic, but you can't convince the court if your communication's not good, because you're going to be parents for these children for the rest of their lives. So you have to communicate, put your egos, aside and just focus and keep your topics and discussions child focused, but communicate, for God's sake. You don't want to go through lawyers all the time.
And respectfully.
Yes.
Communicate respectfully. Be very mindful of your communications. We do see them.
And if you do want that maximum parenting time, but you don't want to encourage a relationship. So let's even say in a scenario where all factors considered, it might be appropriate. I'll just say dad. It might be appropriate in this case for dad to have the child primarily. But because it looks like you might not facilitate a relationship with mom, then the scale kind of tips in favor of giving mom way more parenting time because it appears that you're not going to facilitate that relationship. You're not going to be cooperative, even if all other factors seem to be weighing in your favor. So that's something that you want to be mindful of.
And sorry, Angela, just to add, if you have been early on in your stages ordered to use a third-party application like AppClose or our Family Wizard, and say later on things are heated, even though sometimes we see in family law cases they do die down, but you know, if it's a contested or contentious issue, don't stop using that app. Still communicate, right? If you arbitrarily decide to, oh, I'm not going to use it, it's actually going to make you look bad.
Yeah, true. Exactly. And well, even if you do communicate by text, we will get those text messages, as
Yes.
Sheree said. So, just kind of think about the fact that your emails, your texts and communicating through those apps are something that lawyers and judges and multiple people are going to be looking over. And yeah, just be cooperative, respectful. And if you don't want to see it all over the internet the next day, don't do it. You know what, that doesn't even count. Some people don't care, but we do. We care about you, we care about your family, we care about making sure that you have this, the maximum amount of time, parenting time that is best for your family. So just listen to us and don't say any wild stuff. So the presence of family violence is a factor that the courts would consider in looking at what's in the best interest of the child. Um, and I know, like Tabina, you touched on this earlier in terms of violence against a parent versus against the child. Um, and those would be sort of clear-cut scenarios. Obviously, if a child's being physically abused or whatever, that's very clear-cut how that should weigh into parenting. I'm just gonna put it out there. Maybe there should be no parenting time at all in those circumstances. But let's say, in this case, it's one parent, and I'm going to say the female just because a lot of family violence is mostly gender-based. It happens to a lot of men, and I do have a lot of male clients where this is a factor on our matters, but just because predominantly the numbers are female, I'm going to say she. So let's say we have a scenario where, mom is being abused, maybe verbally all the time, always put down emotionally, psychologically. It might have an impact on the parenting time that's being ordered simply because again, we're talking in terms of communicating, cooperating. It might impact mom's ability to have a voice in this scenario. It might affect the dynamic of the family and sort of what the child is exposed to and things like that. So I don't know if anyone wants to add something there, but this really takes a file for me from just semi-simple to takes it to a whole other level because and the act does that as well. Like family violence is something that we need to take serious action against, and there's various factors in the Divorce Act and the Children's Law Reform Act where the court has specifically mandated to look at these factors that deal with family violence. And okay, I'm gonna blab, so I'm going to stop there because I do have a lot to say on that, but it has no place in society, and it's just disturbing when we hear, certain news. And for us working in the justice system, we want to be able to do our part to try to identify, to try to think about it when we're crafting parenting plans, and we hope that judges are becoming more live to this issue, not just on the basis of just it was the child abuse. Were you a good dad while still being, an abusive husband? That may be the case, but I think it's a whole bigger conversation than that, and it's been given the recognition it deserves. Any thoughts, or did I just
Yeah, no, I believe that like at the end of the day, it does have an impact on parenting. Even if the violence is directed to one party, if the children are exposed to that, it also there's a power imbalance, of course. If someone's seeking shared parenting, but these parties cannot get along, it's going to be very difficult. They're going to ascertain, okay, they're going to adjust the parenting, because the kind of level of communication that's required when a parenting is shared is different than the level of parenting, that the different communication that's required when it's alternate weekends. So at the end of the day, if the children were directly, even not, and I wouldn't say directly, but maybe they weren't the source of the violence, but they had seen it, and psychologically maybe they don't agree with it and they don't like, I'm going to use your same gender example, but maybe they don't want to spend time with dad because as a result of years or consistent exposure to that violence. So all of these factors bleed into each other. They're not kind of just okay, one and done, again, because they're non-exhaustive. But yeah, family violence is very important and it does have an impact on parenting. But I want to say it in the sense that if children were not exposed, or children are young to the extent that they're not aware of the exposure and the violence is directed solely towards one party, it doesn't mean that dad won't have parenting time. So again, it's taken on a case by case basis, but you want to be very careful in terms of how that violence impacts your situation, what parameters can we put in place, and how do we resolve the issues in terms of parenting. But yeah, I think I could also talk on this issue as equally as long, but we're going to move past.
So yeah, and the other two factors, kind of from the Divorce Act, talk about the appropriateness of an order, when you're dealing with and people being able to cooperate, the ability and willingness of a person that's engaged in family violence to care for and meet the needs of the child. So I'm just going to jump to the last one because I think we touched on those two factors, and it's any civil or criminal proceedings, conditions, or measures that are relevant to the safety, security, and well-being of the child. So again, in this case, to kind of draw the distinction earlier, in this case, it's the well of the child, not necessarily of the parent, but do not be deceived. What affects the parent has an impact on the child because it's all, the child is part of a family unit. But yes, so have either one of you, and I know you have had any criminal proceedings kind of affect your family law matter?
Yes, most of the time it's sad to say that like if there are times where the issue is directly with the child in an abuse situation where sexual abuse has taken place and there's a separate criminal proceeding taking place. I've seen that unfortunately a few times, and of course that's a relevant factor because they're not going to want to put the child in a very uncomfortable situation, especially while an ongoing criminal proceeding is happening. Another issue is sometimes especially with older children, I find that sometimes they might engage in violent behaviors with a parent and there may be charges laid, which means that there may be a no contact order between the parent and the child, which would undoubtedly affect parenting. Maybe never forever, but maybe it will. You just don't know. So again, it's by case. Another factor is if there's a history of domestic violence or domestic incident where mom has a restraining order, but it does affect the well-being of the child given that restraining order in place against the other party.
Yeah, absolutely. Tabina, did you want to add anything to that? Or we're
No,
good with
I think
the summary?
trains, yeah, covered it. Thank you.
Yeah, I think so as well. So those are sort of as Turin keeps reminding us, the non-exhaustive factors when we're thinking of the best interest of the child. So I'm just going to recap by saying, the law is that you should have the maximum amount of parenting time that is consistent with the best interest of the child. And we've spent all this time talking about what we look at when we're talking about the best interest of the child. Now, we do agree that it's important. There's all this, the social science studies, support the fact that the child should spend as much time with each parent. But remember, that doesn't mean 50-50. It just means, again, as what is in the best interest of the child. There's no, what would be the word, presumption that favors 50-50. It's just, even though you might have been equal, even if both parties agree that they both took care of the child equally during the marriage, it's still not necessarily a presumption in your favor. It's what's in the child's best interest. So, hopefully this kind of helps you if you're thinking through what parenting time would be best for your family. And as always, if you have any questions, we're here to help. And that's bye for now. Oh, first I want to say a huge thank you to you ladies, because this was one of those days where we powered through. We had sort of a discussion earlier on a separate topic. And, this was a question that came to us and we thought, you know what, this is pretty important. We want to put out this information out there. We hope we're helping families. It's truly our goal here to help make family lives better. And we hope this helps in a little way. It, hopefully it does that. So until next time, thanks ladies, and bye everyone.
Have a good night, everyone.
Bye.